Yeah, yeah, yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. Good morning. Good morning to all of you. It is Pam Esquire, also known as Your Law Intellect. I figured that I would come on early this morning because I had like a 9 o'clock hearing. All right. So while I'm here, I said, well, let's just go over this new information that dropped on Pacer related to the Sean Diddy Combs trial. Because the more I scroll, the more I see that people have no clue what they are talking about. As an initial matter, the government did not drop any charges. His charges are 5 counts. You have racketeering conspiracy, count 1. You have trafficking, count 2, related to Cassie. You have count 3, which is also related to Cassie, which is the institution under the Mann Act. We got count 4 and 5 are the same that Cassie received, the trafficking and the institution, and that's because that's James. That's for James. And so, listen, they have not, I repeat, dropped charges. Those are your charges, all right? So let's just start with that. I promise y'all this sun was not even out here before I decided to come out here because it rained all night. Now it's hot and the sun is just beaming on my back. Okay, I got this little fan on, so if it starts bothering you, just let me know and I'll cut it off. I'll endure it. You know, I don't plan on being here long. So what has happened is, and this is one thing that I told you, so if you're an intellect, you already know. If you follow me, and it shouldn't be new news, in the beginning, when in opening statements, the government is going to say, you're going to hear testimony about ... Okay, they're going to tell you all of that. What I told you all is what's going to happen is the defense is going to be over there keeping copious notes to make sure that the government proves every single thing that they said that they're going to prove. This is what they told you all. This is what they vowed to the jury they're going to prove. So they're going to get up and they're going to say they did not prove A, B, C, D, E, G, whatever. And so what happened is, as this trial progressed, in my opinion, I think the government realized there were just certain things that was not proved. Okay, was not proven. However, if you look at the indictment, there was a whole lot of predicate acts, a whole lot that they are alleging in this case. And so will it really affect like that? Probably not. But let me see, hold on. And in my opinion, I don't think the government knew what they're saying. They're trying to quote streamline, and we can pull it up, streamline the process and, you know, make it easier. You know, they're not going to just say, we don't think we can prove it. But that's what they basically were saying. But in my opinion, I feel like they just knew after they went through it. And this defense is going to pounce all over it. And they're still going to pounce all over it. I think if the judge, you know, agrees to amend, however they're trying to amend it. But let me pull up the indictment real quick so you guys can be refreshed on what the actual predicate acts are. Yes, make sure you hit the like button for your girl. So if you go down to the racketeering conspiracy, hold on. Always go back to your authority. If you go to the racketeering conspiracy, they say specifically from at least in or around 2004 through 2024, the defendant and others known and unknown being persons employed by and associated with the Combs enterprise described in paragraph 6 through 12 of this indictment and enterprise engaged in and the activities of which affected interstate and foreign commerce knowingly combined, conspired, confederated, and agreed together. So, racketeering conspiracy, that's why I said the word conspiracy is actually important in this case, because you do have just a straight RICO charge. And what happened yesterday when the defense was arguing their Rule 29 or their motion for acquittal, one of the things they pointed out was Christina Coram, you're saying she's the co-conspirator. She didn't get involved till 2016. So we starting out in 2004, which we know, I told you all, the only person we really saw that was around in 2004 is Capricorn Clark. What is Capricorn Clark connected to? She is connected to the actual all of the issues related to Kid Cudi. The kidnapping, the arson, all of that. She got, yeah. So when you look at the racketeering activity as the term defined in Title 18 United States Code Section 1961 Sub 1 and Sub 5, they say multiple acts involving kidnapping chargeable under the following provisions of law. They got kidnapping. Okay, so they still have kidnapping under the law. They didn't say they was taking that out, but then they say attempted kidnapping. So that's the part it sounds like they're trying to take out according to the letter. Aiding and abetting, conspiracy. Then they got another kidnapping. So all of this stuff is what they're saying. So them taking out an attempted if the jury hypothetically felt like they were two predicate, they only need two predicate acts. But what I think the government is trying to do is they're trying to make sure, because sometimes people have the thought process of you didn't prove what you said was going to be proven in this case as it pertains to one, and we're going to assign that to others that you probably ain't really do what you were supposed to do on the other ones. They're trying to be as clear and concise as possible so there's no look of we didn't prove that specific argument beyond a reasonable doubt. But apparently they still feel like they kidnapping, because I think they just were requesting to throw out attempted kidnapping. So they still have the kidnapping. They got conspiracy, they got kidnapping, and they have another aiding and abetting. So they have to prove all of that. So they're saying these predicate acts, they know they have not necessarily proven that, and it may just confuse the jury because you have to show it in a conspiracy, an agreement. So can you show that there was some type of conspiracy when it came to these specific predicate acts? Multiple acts involving arson, chargeable under the following provisions. Even though we only heard of one act of arson specific with the word arson, we only heard one, and that's the Kid Cudi. And it has California Penal Code Section 451, which is arson. Then they have the Penal Code 21A, which is attempted. That's the part that they're trying to take out. Then they have aiding and abetting, conspiracy. Multiple acts involving bribery, chargeable under the following provisions. And then they have bribery of a witness. They didn't say anything about that I recall. Didn't say anything about informant. Didn't say anything about forced labor. Ex trafficking. Then they have related to transportation and inducement to travel for purposes of prostitution. And then they also have multiple offenses involving possession with intent to distribute or distribution of narcotics and controlled substances. So that is all that really happened. So anybody basically saying, oh, they dropped the charges, that's not true. The predicate acts, they had, as you see, multiple predicate acts they're alleging. And I think they're trying to get rid of the ones of which they have not proven beyond a reasonable doubt, even though they'll say, well, because you also have to prove the predicate act beyond a reason. I believe it has to be unanimous on what the predicate acts are under RICO. So yeah, so that's the reason why. Now, if the defense, and I was just talking to another lawyer this morning, we were talking about it. I said what I told you all when we were discussing. I'm like, they're trying to eliminate, in my opinion, the defense of, you didn't prove this, so you probably didn't prove that. So they're trying not to muddy the waters too much, because let's be clear, the government already acknowledged they watching the YouTube streets. They're watching social media. They can say they're just watching to make sure we don't say who Jane Doe is, but they're watching. And they see some of the confusion of other people. And they're like, well, if they're confused, they're the public, they are the jury of our peers, then we're going to try to unconfuse them, and we're going to try to simplify it as much as we can so people ain't confused. Now, that's that. Well, yeah, because I'm telling you, I told you all in the beginning, I said, when we first started discussing this, I said, as defense attorneys, what you literally do, you'll get up there, see the prosecutors, they told you they were going to prove this. Did you see it? Because I ain't see it. You know why? Because they didn't have the information to prove what they said they were. They're just trying to muddy the water. They're trying to make my client, they're being the moral police. They're being the bedroom police. And they're just trying to make my client look bad. So for whatever, come up with their reasonings as to why. So that is something that is prevalent that most defense attorneys do. We hold you to everything that you say that you're going to prove in this case. So this was the actual letter that was filed, and the government, just like we went over the proposed jury instructions from the defense, the government is also now, they're trying to add lines to the jury instructions as it pertains to different charges. The conspiracy, what I mentioned yesterday, they are concerned about the confusion that may come with agreement and conspiracy. So they're going through case law, which I told you sometimes you can try to add stuff to the pattern jury instructions, and you use case law as your authority. Well, we call them special jury instructions. You add case law to your authority. So if that's the case and you're adding case law, that's what they're trying to do in this letter, is to show case law where they can add certain lines to help them. Let's be clear. I think they know. Some people say it's a slam dunk. I'd say I don't agree. I don't agree with that. And I think they know that there may be some confusion. And to me, they confirmed that in their letter that they wrote. So they got together to figure out, how can we basically help ourselves win this case and help the jurors to understand the law. Now, they're concerned about the jurors not being able to understand how to actually apply the facts to the law. And they pretty much said it in here. So we're going to read it. I don't want you to take my word for it. It's only 8 pages. You got time. I got time. Let's get it in. So the letter, which is real, some people were saying they thought it was fake. No, this is real. The government writes, they understand the court's desire for streamlined instructions. So they're saying they just doing this like we're trying to streamline and see what we can eliminate. With that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed instructions from the charge relating to 1, attempted kidnapping under both California and New York, 2, attempted arson under California law, and 3, aiding and abetting trafficking. The government is no longer planning to proceed on these theories of liability, so instructions are no longer necessary. So they're not going to proceed on those. The government has also attempted to simplify the language relating to count one, which is the racketeering conspiracy, a proposal as explained in the government's comment bubbles that the government hopes not only serves the purposes of streamlining the instructions, but also will avoid any confusion as to the operative agreement for count one. So, this is the first point that they're trying to get in with the ex trafficking and forced labor instructions. While the government has taken seriously the court's desire for brevity, the government still strongly believes that certain limited additional instructions on ex trafficking and forced labor instructions, which are regularly given in ex trafficking and forced labor trials in this circuit, are necessary for the jury to adequately understand the law on these charges. So they basically went through to try to find authority for them to say, well, it don't have to necessarily be this. Just because you don't see this doesn't mean it's not ex trafficking. Yeah, you might see some consent, but just because they consented a few times, things that came out in the trial that they cannot argue with that came out, they're finding case law to say it don't necessarily have to be this, and we feel like the jury should be able to consider that. So, each of these instructions reflect established case law and are directly relevant to key issues in this case. Moreover, without such instructions, the government has serious concerns that the jury may misunderstand the applicable law for both charges, which are extremely complex legal concepts of which jurors may have preconceived mistaken notions. And that's what I told you. I'm like, why everybody saying this stuff is so easy? It's not, it's complicated. Now you get the government saying they know that it's a complex, quote, it's a complex legal concept. And so they don't want it because it's complex. The government is like, wait a minute, I'm seeing what these people out here talking about. What if the jury is thinking the same thing? They ain't proved nothing. What if the jury is thinking that? So now we're going back to the drawing board trying to make sure we find authority that it's not what everyone may think has to be proven, but they only need to prove this. Okay. The government has listed the precedent for each of the instructions in its comments to the forced labor and ex trafficking sections of the request to charge. To avoid repeating that law and precedent here, the government limits the below largely to providing the government's reasons why, based on the particular facts and issues in this trial, these additional instructions are necessary. So as to ex trafficking, remember earlier, consent not determinative. When you talk about Cassie, even Jane, most of them said they consented. There's text messages that were entered of which now they don't want the jury to say they agreed to all of this. So they want the jury to say, well, like some people were saying in the chat, if you say no one time, that's enough to say it was ex trafficking. My issue is that with that also is if there are limitations on some of this stuff, wouldn't you have to know when that no was? But anyway, I'm just going to read. Due to the particular facts of this case, the government believes that it is imperative that the court inform the jury that prior consensual ex activity is not determinative of whether a victim was ex trafficked. As this court is well aware, the facts of this case involve instances of trafficking of Jane and Ms. Ventura that follow instances of consensual sexual activity. So they had to concede that. A topic that is likely to be addressed extensively by both parties during closing arguments. And it is Second Circuit law that the earlier period of consensual activity do not preclude a finding of trafficking to later activity involving a victim. So now we got to pick and choose, well, when was the timing of this and that, and when was really consensual, and with Cassie, the issue is a lot of the stuff she didn't directly tell him, she just told other people, allegedly. So they bring up United States v. Rainier. Okay. Remember, I told y'all, and this is what can happen when you're a lawyer. Rainier is a case that Diddy's attorney was on. I think that's the case with Agnifilo that I told you he got 100 and something years. They're using that when he basically appealed, it looks like, as their authority, which recognizing the ex trafficking encompasses acts that compel a person to perform or to continue performing commercial sexual activity. That's their authority for that. I don't know. I would have to read the whole case because I'm not seeing that quote applicable. But the fact, and then they have another one, US v. Marcus, which is in the Second Circuit, a 2010 case. The fact that Jody's enslavement arose from her initial participation in consensual BDSM activities does not require a contrary conclusion. Yeah, I would have to read those cases. The same is true for forced labor. The government's forced labor theory focuses on 4 victims, Cassie and Jane, with regard to their participation in freak offs or hotel nights. But I mean, and Mia and Capricorn with regard to their employment for the defendant. Similarly to ex-trafficking, Cassie and Jane's prior consensual sexual activity do not preclude a finding that later non-consensual sexual acts are forced labor. US v. Zongs, which stands for the proposition of victims' initial willingness to perform certain labor does not preclude the possibility that the victim's continued labor may become forced. It doesn't preclude the possibility. Nor does the fact that Mia and Capricorn willingly took jobs with the defendant preclude a finding that both at some point were forced to work. They're really kind of using this, conceding to some of the points, but they're trying to find case law to say that even though they may have done it willingly, consensually, asked for a job again, that don't mean that at some point it wasn't forced labor. That's basically what they're saying. To avoid any confusion on these points and to ensure that the jury applies the correct law of facts to this case, the government respectfully requests that the court include such an instruction. So ultimately, they're going to argue it today, I think at 2:00, and we'll see what the court says. This is the requested instruction, payment not determinative. So they're requesting that payment also is not determinative, because that's another thing people were arguing, like, well, where's the money? How is he making money? And so if it's commercial and there's no money, then what are we really doing here? So they requested a jury instruction. The government respectfully requests that the court instruct the jury that ex-trafficking and labor and payment to the victim for the conduct are not mutually exclusive. For ex-trafficking, this instruction is crucial because of the fact pattern underlying Jane's trafficking by the defendant. As Jane testified around is this guy serious right now? I'm sorry, y'all. He just decided to start blowing stuff in his backyard. I think he's leaving for now. Okay, for ex-trafficking, this instruction is crucial because of the fact pattern underlying Jane's trafficking by the defendant. As Jane testified around April 2023, the defendant and Jane's entered into a multi-year love contract under which the defendant agreed to pay Jane's rent in the amount of $10,000 each month. While that contract was in effect and in part as a result of terms of that contract, the government alleges that Jane was trafficked. Because jurors may be under the mistaken impression that someone cannot be coerced if they receive compensation in return, the government requests that the jury be instructed as to the law that payment alone does not preclude a finding of guilt as to ex-trafficking. And that's US v. Riviera, which affirming conviction despite victim's statement that the defendant paid them and they earn more money than they would at. Why would anybody argue because I paid them they weren't ex-traffics? Why would that even be that's not clicking for me. Anyway, because the forced labor victims also receive money or gifts from the defendant, it is important to instruct the jury that payment does not preclude a finding of forced labor in order to prevent confusion. Because from what I heard in the transcript, or what I saw in the transcript, and what I've heard online with Jane, okay, the first couple of years he wasn't paying her on a regular basis. She requested almost an allowance to be paid on a regular basis, being one of his girlfriends, a concubine. So I'm not getting this part. But as noted above, the defendant paid Jane a $10,000 per month rent and similarly paid for Cassie's rent and other expenses. In addition, as employees, Mia and Capricorn were paid salaries by the defendant's company. The jury may not intuitively understand that this payment does not preclude a guilty finding on forced labor. Requested instruction 3, cumulative conduct. The government's proposed additional charge language instructing the defendant that they may consider a defendant's cumulative conduct is particularly necessary in this case for the jury to understand what it can consider in assessing whether Ms. Ventura was coerced. Throughout trial, the government has introduced evidence not only of threats and harms directed at Ms. Ventura over a multi-year period by the defendant, but also the defendant threats and abuse of others of which Ms. Ventura was aware. Under the law, the jury may consider all this conduct in assessing whether a victim was coerced. That's U.S. v. Purcell, and that's a Second Circuit 2020 case. Viewing defendant, which stands for the proposition, viewing defendant's cumulative conduct and holding that the government had met its burden of proving coercion. When evaluating if a defendant exerted coercive force over a complainant, juries are thus directed to evaluate the totality of the defendant's conduct toward a trafficking victim, including any threats of specific instances of past violence that may have created a culture of fear which that the victim's conduct was rendered involuntary. However, without such an instruction, jurors may mistakenly believe that they are confined to considering a narrower category of evidence and deciding whether the elements of sex trafficking are met. The cumulative conduct and forced labor instructions is also important for Mia and Capricorn. Both worked for the defendant over long periods of time, and during their employment, the defendant was violent and threatened them. The cumulative effect of the violence and threats can all be considered by the jury in assessing whether either was forced to engage in labor or services for the defendant. Without an instruction of this nature, jurors may feel they are constrained to consider only whether a particular act of violence or threat resulted in forced labor. Physical restraint, that's the requested instruction 4. Based on the cross-examination of Jane and Mia, the government respectfully requested the court briefly instruct the jury that physical restraint is not required to establish sex trafficking and forced labor. As this court is aware, one of the key instances of trafficking of Jane that the government intends to discuss at length in its closing, and which the government anticipates that the defense will also address in closing, involves the defendant's assault of and subsequent freak-off involving Jane in June 2024. But didn't she hit him first? During cross-examination about this incident, defense counsel extensively questioned Jane about times that she could have escaped on that date. Asking, like in the transcript, they quote the transcript, does the back gate have a capability for you to leave the house? Asking whether she has other members in Los Angeles. Moreover, during today's Rule 29 motion, defense counsel again argued that Jane could not have been trafficked on this date because she could have left. Because of the defense's lengthy cross-examination on this point and expected arguments at closing, and to avoid confusion, the government requests that a very brief instruction be added on this point that makes clear the legal import of this evidence. Similarly, during the cross of Mia and in the Rule 29 argument today, the defense repeatedly argued that Mia could have left her job at any time and is therefore not a forced labor victim. That is incorrect under the law. They cited Riviera with affirming forced labor and ex-trafficking convictions, even though victim once left the defendant but later returned. And the instructions is needed to correct any misimpression of the jurors' mind that Mia had an affirmative duty to leave. The next requested instruction has to do with the ex-trafficking. Defendant need not receive thing of value. So that was what some of you all were saying, like, but he didn't make no money. And so they're saying you ain't got to make no money. The government respectfully requested the court add a single sentence to its charge on ex-trafficking to clarify the defendant need not be the person who receives the thing of value under the ex-trafficking. The government believes that this short instruction is necessary here due to the particular relationship between the parties and the potential that jurors will be influenced by the preconceived misconceptions about trafficking that do not comport with the law as it will be explained to them. And under Noble v. Weinstein, they note that Congress noted that trafficking in persons is not limited to the X industry. That's the quote they cited. A short instruction on this point is needed to clarify the proper scope of this statute. Commercial X acts need not occur. Told y'all they've been listening to what you guys been saying in these comments. And honestly, the comments, I told you all when I started this channel, I said you guys are the best test study. What you guys think, I would be looking at what you guys think to see how I can tweak it, because that means other jurors might think that way. Thank you, Queen Brielle, for the gifted membership. I appreciate it. It's over 1,000 of y'all in here. Make sure you hit the like button, subscribe to the channel. Thank you so much, Lolisa. I appreciate you, sis. I'm going to talk about your brother later, but we ain't going to do that right now because I still got another hearing. Andre Styles said they definitely haven't proved forced labor. Okay. That's from Andre. See Through You said, okay, that wasn't, I don't want to go when y'all having your conversations because I get one part and get confused. Ray said forced labor in any situation where someone is compelled to work against their will through harmful means, including physical harm, threats, deception, or restriction of movement. That's from Ray Bishop. That is the co-counsel of the platform. TLC Necessary said X trafficking is a $1 billion industry being ignored by the government. Instead, we wasting tax dollars in this mess. We deserve a refund. You are not getting that, child. They've been waiting on reparations for decades. Shantae said Jane lived across the country and her FOs were like once a month. I think Jane is difficult for a lot of people, partially because she initiated some of it. She set it up for Valentine's Day, I think. She also used it and tried to say she only did this one time. I don't believe she only did it one time. And I said it before the text even came out. She probably knew Diddy wasn't into her like that and wasn't looking at her as being a for real, like in public, like a Miami. I do believe Miami triggered some people, and I think she's one of them. And so she wanted that where people knew that they were together, even if it was just a dating situation. Because Diddy, when it came to Miami, he said, I'm just dating, I'm single. He never said, like she said, we go together real bad, but he didn't say. He was like, oh, okay, you say so, but yeah, I'm single. She wanted that. And so when she seen him out, she must have known that perhaps Miami I'm not saying whether she did or did not all this stuff. She said she didn't. So I'm going to go with what she said. Whoever he would go out to these places with, they may not have been doing these freak offs or these hotel nights. So she used it at that point. If you don't get back, you ain't never getting a freak off again. So she actually used that as a way to almost stay in his orbit. I'm not saying he ain't care about her at all, but I'm saying he was probably willing to stick it out just a little bit longer because of his appetite that he had. So with Jane, I think it's a difficult situation with Jane. With Cassie, we know, of course, she started out, she was a bit younger. Jane was about 10 years older than what Cassie was when she started seeing Diddy. And also with Cassie, he wasn't abusive to Jane. That whole violent situation they had was Jane started it, and apparently Diddy finished it. But she knew from the lawsuit that he had done this with Cassie. And allegedly, according to her, he said Cassie was like, he said that Cassie was a fighter to her. That's what she testified to, Miss Jane. So even with the Cassie situation, it was domestic violence. Like a lot of that was abuse. But what the government is trying to paint, and they want the jury to believe, is that no, she stayed around and she involved herself in a lot of this stuff, in the trafficking or these freak offs, because he was violent and he was threatening her and people around him. So just generally, because he's a violent person, because he was violent, he had a DV relationship with her and it was very toxic, that we want you to assume, I guess, that she wanted to leave, but she didn't want to participate, but she just chose to. because she was scared of him type situation. So that's like the violence threats. So they're trying to add little liners and they're fishing for cases in order to support their theories so that they can try to debunk the defense's argument. So you already know they're about to fight tooth and nail in order to avoid this type of additional instructions to be added to those instructions. But this is what you do. You fight. They're going to try to, they being the defense, are going to try to find the best instructions that they can get that they think will benefit them, and the government's going to do the same thing. LL, thank you for the super chat. Came in late, so Pam, what does that mean for Puff? I don't know. I have to know what you're talking about. I've talked about a whole lot of stuff. Lisa Mooney said, however, he did threaten to tell her and show a tape to her baby daddy. That's extortion. That's her testimony, right? Or was that in a text message? Was that her testimony, Lisa? Or was that in a text message? I don't remember, so I don't want to talk and I have no clue what I'm saying. Mo said, even though she said on the stand she did it because she didn't want anyone else to do it, it's crazy. That's pretty much what Cassie said, and I'm sure line by line, quote by quote, that's what the defense is going to remind the jury. That's her words, but no proof was presented. That's some see-through. Are you talking about? Because we talking so fast. Are you talking about the Jane situation about the baby daddy? Because what you're saying is, let's just assume for argument's sake, because I don't remember if it was a text message or if Jane just said that. Jane was caught up in a lot of inconsistencies. So what you're saying is the jury has to believe Jane's testimony. They can throw Jane's whole testimony out and be like, we don't believe nothing this lady said. That's what they can do. So if that happens, then what? They have to believe that happened. When the Cassie, and the reason why it may be a little iffy is because when the Cassie situation occurred and she said about the $20,000, we've since then saw text messages of which it appears Diddy was asking for some money back at some point, I guess, because he found out that she had been sleeping with the trainer that he was paying for. So he said, should I send the invoice to you, to your man, your mama? And he was like really going off saying he paid $50,000 to the trainer. He paid for her, paid for Carrie. Basically in the text said, both of y'all finessed me out of my money and you were sleeping with the trainer the whole time. She was denying it. She denied that she was sleeping with him, but we all know that she ended up marrying him, having kids. But that was somehow connected. So what if they don't really believe all of her testimony? They may believe some of the testimony. So we just don't know what the jury is going to find credible or not. That's what we don't know. Yeah, Mr. Man, he wanted a refund. You get me, said Jane gives Gone Girl single white female vibes. And that's what Diddy, I guess there was a text where Diddy basically said that as well, said that people warned him of how she was. Shanta 101 said Cassie said he would threaten her with releasing tapes, but then said he paid XXX amount of dollars to prevent them from being released. Right. And she also is the one that had them on her devices. She had access to those tapes. What we have not heard is that in Diddy's house, they found freak off tapes. Have y'all heard that? No, what we heard, and I peeped it out during Cassie's testimony, I was like, so all the devices where you got these tapes from related to Cassie, she had them? How can he hold that over her head if she was the one in possession of them? Now, they can argue, well, he took it on his phone sometimes, so it was in his iCloud. Well, if it was, apparently there is nothing that was presented in evidence that shows that happened. Right. That's Yeah. No, they mentioned it was a text, Andre, and you guys correct me if I'm wrong because this has been a long journey and I'm over it. There was a text message about the cloud, and she was concerned about it still being out there or something, and he said no worries, I deleted it out the cloud or whatever out the cloud. I don't think if it was in the cloud, I think the government would have gotten it. So I don't think that was anything that was proven. All I recall is there was a cross examination of which Cassie, they found three devices in Cassie's home that she turned over. One of them was like not had a manufacturer reboot, so they got it directly off the drive. One of them could be fixed, something was going on with it, but they were able to fix it. Another one had Frank Black on it, so it was presumed that it was probably Diddy's computer. And so they got a search warrant for that because obviously the other two, they were able to get consent from Cassie. So they got a search warrant for the third one that had to do with that they thought may have been a computer that belonged to Diddy and didn't belong to her. She just had it. Betty A, that's the only way that I can't be happier than Diddy to try to get this over with, but I'm ready to move on. Lisa said, I thought the evidence was him threatening Cassie's mother, even though he gave the money back. It's still extortion. Okay. So there were text messages that came out. I didn't upload them to my computer, but I'm going to pull them up right quick and I'm going to read them right fast. Now, do I necessarily know the time date? I'm going to tell you my limitations because, again, this stuff is starting to blend together. But let me see. Hold up. And I got these from Dennis. He sent them to me. So on October 19th of 2018, of course, this is around when they broke up because she was upset. She had already been dating her now husband. However, she was upset because that's around when Kim passed away. And Diddy basically did a post that said that was his soulmate. And that was her trigger. She was like, what I've been doing all these years. How you gonna do me like that? And so that's what made her, I guess, get more serious about her current husband, Alex Fine. And they got married in less than a year after that. So on October 19, 2018, this is a text from Diddy. Out of all the foul ish you have done to me, this takes the cake. You and him need to do the right and reimburse me, please. I want a problem. Probably I do not want a problem. I just can't be played like this. And so then she responds, no, we will, no matter what. You've pushed me too far. Okay. So then Diddy says, you already ran a scam on me with Carrie. You pushed me too far. I'm telling you to deal with it. Deal with it, and we don't have a problem. But now it will be dealt with today. Let's me, you and him get together. I hired him to train you, not to hang out with you and become his friend. Someone is giving me my money back, and y'all can have each other. Why did you have to do that with someone I was paying for? Anything more than that is disrespectful, and he disrespected me. So then he do emojis of a broken heart. She hurt his feelings. I'm sure you heard her feelings dragging her down that hallway, but that's, I digress. So then she says, I don't owe you ish. You owe me. He says, deal with that and we're done. Y'all ain't playing me. She responds, and you aren't playing me. We're about to have a big problem. This Cassie talking. Because all you do is harass me for ish that's wrong. He responds, he being Diddy, I'm asking you to deal with it. If you deal with it, we won't. So then she said, blocked, like she wrote the word blocked. So then he says, do you think that was right? So apparently she ain't really blocked him because he literally just responded. He responded like it was 6:35 and 18:21 seconds. He responded in 6:35 and 24 seconds. So wasn't no real block. He says, I just told you I didn't. This is what she said. Okay, so he says, let me go back. Do you think that was right? She says, I just told you I didn't. And you're wrong. I've been telling you. And now I'm done. So he responds, I will handle with him. Are you going to give me my money back? She said, trust. He responded, what does any of that have to do with you effing with the trainer? Is that your justification? It's foul. You can't admit that. And I'm tired of you threatening me. I think you need to fix this. And you're the one with the threats. And I'm not releasing anything. You're threatening me. And I'm letting you know it goes both ways. So she's saying, he's like, I ain't threatening you to do nothing. What are you even saying? So then she responds, hit him. I have nothing to do with it. She said, done. He responds, how are you comparing her to a trainer I paid for? So she bringing up, you got your O's. So what's the problem? She responds, effing Carrie's friends are ninja. So apparently he must have messed with one of Carrie's friends. She said, F you. So then he says, so you want to hurt me because you effed with the trainer? Release the videos also. So then she said, I didn't. Stop accusing me. Release that videos. So she's saying release the videos. What videos are we talking about? Release that what videos? Okay, so she didn't say that. She said release what videos? So then she said, you're a lunatic and I'm done. And no, I didn't pay for that biatch for her services, but I have had her blacklisted as a fake arse model. So she said, nah, I didn't pay her for her services, but I got her blacklisted as the model. So maybe he didn't mess around with somebody who was styling her or something. I don't know the context. I'm speculating. She says, like beyond. She's over it. Now you have it as a point. Hold on. Now you have it at a point. Everyone is going to know exactly who you are and what you've done if they don't already. So she telling him, I'm about to tell him about all our business. So then he says, let him know that as a man, he now needs to deal with that. Did he just want his money back from this trainer you've been banging? I'll let him know. You have this ish real messy. I refuse to let a white boy that I paid to train you F you. You let everyone know that I effed with Gina, and everyone will know you effed with him. And she said, I'm telling you that you're wrong. He said, why did you have to do that knowing I was paying for it? Damn, wow. Like he feels so played. See, when the player gets played, it's hard for them to swallow. So then she responds, but I'll make sure that your lawyer receives pics of my face and body. So she's letting them know I took pictures in 2018 of you beating my behind. And so I'm going to send them to your lawyer. So you play if you want to. You go ahead and play. You might want to think that through before you tell people I'm messing with Alex. That's what you better do. So then she said, every time you beat me up. Now that's 2018. So then he said, I really advise that y'all address this, please. Thank you. I won't buy. He keep reverting back to, girl, forget all what you talking about. If you don't give me my money back, I want my money. I'm getting the invoices from Jamal. So he said, I'm getting these invoices. Somebody paying me my money back. So she responds, I told you I didn't hook up with him in the house. I don't know what you're talking about. Seriously. And you owe me my face when I almost lost it a few times. So every time he checking her about I'm paying this trainer that you sleeping with, she go back to you were beating me. You've been beating me for 10 years. You owe money. You owe me because you almost took my whole face off. What are you talking about? Damn. She says, so if you don't want problems, you can leave me alone. So she's just threatening, likes to let everybody know you's a woman beater. So then he responds, whether it was in the house or his or a hotel, I was still paying for him. Do you think that's right? So where did you hook up with him at? Do you think it's right that I was paying for the trainer you was hooking up with? Wherever. She says, you are so wrong. That's how many O's she got. So then she sends a picture, look like a Gina. She said, my get back is better than yours. She sends a picture of Gina. So then he responds, you wasn't paying for her. I was paying for this cat. Like, you can put Gina all you want to, but you ain't pay for Gina. You ain't had, like, you literally took my money and then you slept with the trainer. He is, when I say bringing her back, he keep reeling her back in. Like, we gonna get to the issue at hand. You wasn't paying for her. I was paying for this cat and I want all my money back. He said, you not gonna let y'all two cornballs play me. How are you even comparing the two? I had this cut off. Hold on. Okay. I have this man something to deal with. Deal with that. You can F whoever you want, but the person I was paying for. That's something me and him got a remedy. So let him know I'll be in contact. And I think something about an address and give me my money back is cut off. If it wasn't about the money I paid him, I wouldn't. Like, basically, I wouldn't care. But it's about how y'all took advantage of me and you know I'm everything. I'm too nice or whatever he said. It was cut off. Then he says, tell your mama and your daddy about it. Or I definitely will. I was paying $50K for this ninja. Then 18 for you and Carrie. And you effing me both ways. Effing foul. I promise you, you will get nothing good back for your karma. I was paying for this, and you won't even come clean. You are evil. So then Diddy goes on to say, I think I just saw something about it on Instagram. I'll forward it to you. You should get your publicist on this. And oh yeah, tell her send Alex the invoices. And then your friend extorted me, and he got 5 exclamation points. So he really mad. He's shouting. He got like 5 exclamation points. You really got a foul, evil thing going on with 5 more exclamation points. Please stay away from me. You go your way and I go mine with 5 more exclamation points. Then he got it in all caps. You know how I feel about all caps. He's serious. No problem. God bless you. For real, I pray your karma don't hit you more than it is now. Because you're a piece of work on the low. Girl, you got everyone fooled. Good for you. Hope it continues to work for you. Love, number, blocked. Then he ended it with love. So then he goes on to say, because he ain't finished yet, he thought about it a little bit more, because this was at 12:36 a.m. on October 19th, and he thought about some more on October 19th at 5:55 p.m., where he said, you did me dirty. He been talking about this all day. I actually spent $50K on this cat. Are you going to do the right thing and reimburse me? I need to know how you think you and him are going to play with me like this. He giving me back my money himself. Let him know I'm coming for mine. Y'all will not take my money and F me over. like I'm y'all sucker. Karma, karma, karma. Oh, he was crashing out. Then he then he sends the picture of Alex. He says, he said, no, you are. He said, no, you are. You went too far this time. So then he says, just got a call from TMZ about Alex. I will confirm. So then she responds, you on some bullshit. He responds, that's what you want me to do, right? So then he responds, I really need to tell you something. I've never asked you like this. Please, for any good for please for any good I've done. It's October 19th at 12:06 a.m. So then there's some attachments and then there's some audio messages. And then she messed around and got 20 million off of him after all of this. So I don't know. Then got 10 more million off the hotel. Hmm. So Lisa, does that answer your question, Lisa? Oh, thank you, Unicorn. I was just trying to let you guys feel like you were in there, when they was talking on these texts. Diddy was crashing out. He felt like all that playing, he probably done played people and now he got played. When the player gets played, it is a bad moment. All right, y'all. So we got to finish this because I still got work to do. Still don't see where he said, I'm going to tell your mother. So, Mo Better, what happened is there was an email where Cassie sent the mom and she sent, it may have been Capricorn. She sent a couple of people an email and she said she needed $20,000 or Diddy's going to release an X tape. It was the email. Now, I don't know the date of that email. So that's what I'm saying. I don't know how connected it is. So I don't want to make it seem like I know the date of the email because I don't remember. But there was an email of which that's supposed to be, it wasn't Diddy asking her, it was him saying something about that, you know. And so she sent the 20,000 because she was concerned. And then I guess Diddy's people sent it back. So yeah. It might have been Andrea. It might have been 2016. I don't know. Happy birthday, Val. Happy birthday. Y'all wish my sister a happy birthday. You said she's in fear but talks like that. She said, because if I would have been fearful, it definitely would have been to be talking to somebody who I know this goofball lunatic is paying for if I was scared. But that's just me. Everybody reacts differently. I'm not saying people gotta be like me. Not at all. The real Empress says, so this is why he wanted Alex out of the courtroom. Could be. Thank you for the super chat. Libra said he been paying people to sleep with her. What's one more? I don't know what that's referring to, Libra. You have to let me know now. All right, let's get back to this. Make sure y'all hit the like button, subscribe. It's 1,300 of y'all. So make sure you let everyone know you're enjoying the content. We're just going over what the government said because apparently people don't know what they said. Even though it's here in black and white. No, they're not dropping any of them charges. Okay. They're not dropping any of them. They are trying to dismiss some predicate acts that they probably know they have not proven because they don't want the defense to come back, which they probably will anyway. They don't want the defense to come back and say, they told you they were going to prove this and they didn't do it. So, anyway, the next requested instruction, 7, is reckless disregard. The government respectfully requests a more detailed reckless disregard instruction. The government anticipates that one of the key disputes as to counts 2 and 4 Those are the trafficking. Is that the traffic? Yeah, I think that's the trafficking. Will be whether the defendant had the requisite knowledge that Jane and Miss Ventura felt forced into engaging in these commercial acts. While knowledge, a term people use in their everyday lives, is likely to be readily understandable to the jury, the government believes that additional explanation is needed to explain the term reckless disregard. See, one of the things that I think the defense did well in is that they did show that with Cassie specifically, there was no knowledge, that she was basically saying that she didn't want to and all of that, or she would do things like say I'm hungry or try to do these cues, but it may not have been necessarily I don't ever want to do this, why are you making me, like it wasn't anything like that. Allegedly she told the hairstylist and maybe somebody else, but as far as him, so I'm sure when it comes to Cassie, he's gonna say it's no knowledge. When it comes to Jane, I think he's still gonna say no knowledge, even though she had a couple of times, you only used me for this purpose. A lot of that was after the lawsuit. However, she would come back after saying she didn't want to do it. You come back and set it up yourself. So it might have been like a little mixed on the knowledge aspect of it, right? So they said knowledge obviously is the everyday term, but they don't think that the jury will understand necessarily the reckless portion of it. So the reckless disregard is basically you may not have known, but you should have known. So you should have known that nobody will want to have urine in their mouth. You should have known that they got tired of being your freak machine. You should have known that their mouths got tired. You should have known they didn't want to share their bodies with anybody but you. That type of thing. So then for the conspiracy instructions, this is the part that has been the most difficult for me to connect in this case. So the government's proposal also requests certain additional language outlining the law on conspiracy. The current definition is only a few sentences long, and the government is concerned that it may leave open too many unanswered questions for jurors, which will result in a number of jury notes seeking clarification. It is imperative that the jury understand the law of conspiracy, a legal concept that is not intuitive, in order for them to correctly apply that law to the facts relevant to count one, as well as the narcotic conspiracy predicate. The government has carefully gone through conspiracy instructions that are regularly given in this circuit and has only proposed adding that language that is directly relevant to issues in this case. The government is available at the conference to answer any questions this court has about why such instructions are necessary for this jury to understanding this case. Effect on interstate and foreign commerce. The government requests that the court add a short instruction in this discussion of the interstate commerce element of the racketeering conspiracy, that narcotic activity has an effect on interstate commerce as a matter of law. So on the portion of affecting interstate commerce, some people think financially, but they're saying if you deal drugs, which is true, that's why part of the issue when you are a drug trafficker is that it affects interstate commerce. So they're saying they want on the element of racketeering conspiracy related to the narcotics activity that it does affect interstate commerce as a matter of law. They're going to argue, obviously, it was a personal. It was all a personal. I mean, even the assistant said it. Yeah, it was a personal. It wasn't like a whole lot to be supplying and people coming over like, can I get, some kilos? It wasn't anything like that. It was literally he was getting it for personal use. So indeed, the Second Circuit has found that narcotics activity satisfies the interstate commerce requirement for a racketeering enterprise. So that's United States v. Miller, a 97 case, where it held that of special importance to the present case. We have held that because narcotic trafficking represents a type of activity that Congress reasonably found substantially affected interstate commerce, the actual effect that each drug conspiracy has on interstate commerce is constitutionally irrelevant. It follows that whereas here, the RICO enterprise's business is narcotic trafficking, the enterprise must be viewed as substantially affecting interstate commerce, even if individual predicate acts occur solely within a state. This just sounds more complicated. Okay, so then they go on to Taylor v. U.S. The Supreme Court found that the interstate commerce elements of the Hobbs Act robbery is satisfied if the government established that the defendant robbed or attempted to rob a drug dealer of drugs or drug proceeds. Since it's a matter of law, the market for illegal drugs is commerce over which the United States has jurisdiction. And while the Second Circuit has not had the opportunity to apply Taylor to the RICO statute, it is held that Taylor applies to violent crimes and aid of racketeering. So they got a bunch of law and all of that. For that reason, courts in this district have also consistently instructed the jury that narcotics activity satisfies the interstate commerce element under RICO. Okay. Then they go on to venue. The government respectfully requests that the court modify the instruction currently included in the discussion of venue that ministerial functions and preparatory acts occurring in the district are insufficient to establish venue. The circuit has held that venue may be satisfied for ex trafficking where a defendant contacts a victim who is located in the district for purposes of enticing them to engage in ex trafficking. That's US v. Wash. And in that case, they found venue satisfied where, quote, a minor testified that Benjamin first contacted her using Facebook Messenger in the fall of 2015 when she was living in a residential treatment center located in the Southern District of New York for purposes of enticing the minor to engage in prostitution. Since the conduct in Wash may erroneously be construed by a juror as merely preparatory, the government requested the court modify this portion of the venue instruction to reflect the language in U.S. v. Beech Nut Nutrition Court, which is the Second Circuit 1989 case, by clarifying that acts that are preparatory to the offense and not part of the offense are insufficient to establish venue. However, the inclusion of the term ministerial functions may further confuse the jury. That's what I was. I'm like, this sounds more confusing. And in any event, does not appear to be relevant to the conduct. In this case, nor is the government aware of circuit precedent for that portion of the instruction. Accordingly, the government requests the reference to ministerial functions be omitted. Okay. The government objects to unanimity instruction for the sex trafficking and Mann Act offenses. The government has been unable to find a single first ex trafficking and Mann Act case when an unanimity, y'all know what I'm trying to say, instruction was given, and are concerned that the language as drafted will introduce error into the charge. Accordingly, the government proposes the following language, which is designed to reduce the risk of error and confusion. The intent of these edits, among other things, is to properly characterize what constitutes the relevant instance and to make clear that this is only needed for elements, not means. So then they say U.S. v. Corley, affirming an instruction to the jury that to convict did not need to conclude unanimously as to how Corley violated 18 U.S.C. 1951, specifically whether he either one harbored or two participated in a venture and harbored a minor victim. Because harboring and basically how they did it, they don't have to agree with how they were able to do this ex trafficking. That don't have to be, because there's some things that have to be unanimous. So like when you go through the racketeering, the actual predicate acts, they do have to place what predicate acts that they agree on beyond a reasonable doubt for the predicate act. So they're saying they don't got to be unanimous on the how when it comes to ex trafficking, and they want them to know that. Oh, so they say counts 2 and 4 proposed instructions. So on count 2 and 4, this is what they want. The government has argued that the defendant committed ex trafficking with respect to Cassandra Ventura for count 2 or Jane for count 4 over a year's long period. To find the defendant guilty of these counts, you must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of ex trafficking within that period. As to that specific instance, ex trafficking, you must agree that all the elements were met beyond a reasonable doubt, but you need not agree as to the way in which the elements are satisfied or all the details of the instances. For count 3 and 5, the proposed instruction is the government has argued that the defendant violated federal laws regarding transportation to engage in prostitution with respect to Cassandra Ventura, among others, for count 3, and with respect to Jane and among others for count 5 over a year's long period. To find the defendant guilty on these counts, you must be unanimous that the government proved beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of transportation to engage in prostitution within that period. As to the specific instances of transportation to engage in prostitution, you must agree that all elements were met beyond a reasonable doubt, but you need not agree as to the way in which the elements were satisfied or all the details of the instances. To the extent the court has questions about the certain of these proposed edits, the government is available to answer these questions at tomorrow's conference. Everyone have a blessed night. Okay, I added that. So that's it, y'all. So all of these headlines, they dropping charges. Sure, they ain't dropping nothing. Okay. They not. They're trying to focus the jurors because I think they know it's all over the place. So they're trying to focus them not to be focused on things that they believe is unimportant and focus specifically on these different elements and how the government thinks that they can prove their elements, because you have to prove each element beyond a reasonable doubt. Okay? Any questions? Because I'm out of here. Okay? It's hot out here and I got to prepare for a deposition. Okay, Power Dynamic, thank you so much for the super sticker. I appreciate that. Darlene, welcome to the 1 year. I appreciate you and thank you for gifting memberships. Tanika, welcome to the Intellects. Thank you so much for joining. Anything else? 1,300 of y'all. Hit the like, subscribe to the channel. Yes, they're trying to get rid of whatever they can so they're not to confuse the jury. That's why when people are like, oh, they've done it. Oh my God, they've done it. I'm like, this is some confusing. It's so convoluted because they added the issue with this case. I mean, there's several issues, but one of the issues is they've added a lot of things that really, in my opinion, has nothing to do with the elements of the case. So now you got all this extra stuff and all this fluff that really kind of went more towards his, they're going to say, obviously, they can't just do this towards his character, but they're trying to say it's related to the actual charges, and maybe it's not so much. And it's almost like they're trying to fix and clean up some of the stuff that they actually opened the door for. But they're going to argue this today at 2:00. I don't know, maybe I think they'll probably argue this all day. So maybe we'll have an evening session. But yeah, that's where we at, y'all. That's where we at. So hopefully this answered your question. So anybody basically saying, child, he walking out, he free. He's not free. Okay, he's not free. Thank you so much. I appreciate it, Tanika, for the super chat. Thank you so much, Dina. Anything else, y'all? Anything else? Going once. Going twice. Thank you, CA 1983, for being a member for 14 months. She said, thanks, Pam. Appreciate you. I appreciate you more. Thank you, Mars. I appreciate that. All right, y'all. I'm out of here. You guys have a great day. Don't get caught up in the media madness, all right? Am I going to be looking at Kevin Hunter's suit? I think you asked me that before. I'll try to look at it. It looks like it's a bit lengthy. You said they overcharge him and they are outlandishly arrogant and unacceptable. No, that's from Steeler. All right, y'all. For real, though. I'm out for real. As much as I love talking to y'all, I got work to do. So you guys have a great day. Talk soon.